Good morning and welcome to this morning's HR Mythbuster. Today we're going to debunk the myth that you need to give an employee 3 written warnings before you potentially terminate their employment. The bottom line is that that's not necessarily the case. It is possible to terminate somebody with, in fact, 1 written warning, or potentially to summarily dismiss them with no written warnings in advance, based on the nature of the event that has taken place or the problem that has arisen, and also based on the process that you follow in order to do this. So let's talk first to the nature of the offence. It may be possible to terminate somebody summarily or to give them a first and final written warning for an offence if it's sufficiently serious in nature that it warrants that sort of treatment. For example, it might be something like theft, fraud, a serious breach of safety, or a serious breach of a policy or procedure that you have in place. For example, sexual or other harassment, bullying, or fighting in the workplace. In the case of a first and final warning, again, it may be one of those sorts of offences that is a little less serious in nature. There are 2 particularly important aspects of this sort of termination or consideration of termination that you should factor into your decision making. One of which is the nature of the policies and procedures around performance management that you have in the organisation and what the person's contract of employment says in relation to termination of employment. And the second is the legislative requirements around particularly summary dismissal of employees. In the case of summary dismissal, courts or commissions will look to a number of factors to determine if the decision that you took was, in fact, a reasonable one. And the first is, in fact, looking at whether or not the decision was harsh, unjust, or unreasonable. And effectively what that means, in simple terms, is does the punishment fit the crime? So it's important that when you are making the decision to terminate with less than 3 warnings, that you have an issue or a problem that is sufficiently serious enough to warrant and pass that first hurdle. The second consideration is around whether or not you've shown the person procedural fairness throughout the process. That would include, for example, issuing the person with a show cause letter prior to termination and prior to the meeting to discuss or consider termination of their employment, which is their opportunity to present their case as to what happened and why. During that meeting, you should also provide the person with the opportunity to have a support person present with them. And the idea of that person is just that, to support, not to advocate on their behalf. So procedural fairness and then substantive fairness, whether or not the punishment fitted the crime, are significant contributors to whether or not your business will be at risk if you terminate somebody for having less than 3 warnings on their file. The bottom line, though, is that it is possible to do, but you should proceed with some caution and always seek advice. Give us a call before a decision is made, and we can guide you both through the process and through determining the rationale for the decision that you're thinking that you might reach. Thank you for listening today, and I look forward to seeing you next time.